Hi there, Peter McKenzie here with Rincon Property Management. I wanted to make a video to go more in depth about the new bill that was just passed, Assembly Bill 3088, the COVID-19 Tenant Relief Act of 2020. So this bill is designed to replace a lot of the other legislation that is out there. So this is a statewide bill. It's meant to replace some of the local moratoriums and the local laws that were passed, but it doesn't automatically replace them. So it prevents any of the local bills from extending. But whatever's in effect right now is going to be in place until it expires. Once they expire, then this AB 3088 will be the law of the land relating to tenant evictions, moratoriums, and that kind of thing. The new law is going to be in place until February of 2025. Unfortunately, the new law is not favorable for landlords. It has more protections for tenants than it does landlords. But we do have to abide by it and work within the confines of it. I just want to say up front, we are not giving legal advice. We are just disseminating information. So I feel an obligation to keep my clients informed when new legislation comes out, and that's exactly what this is. So I just want to go over a quick few bullet points, and then we'll circle back and go into more detail on them. First of all, the law is long and complex, and I'm just highlighting the things that I think are the most applicable to myself and our clients. So one of the things is there's now two categories of tenants who are behind on rent. One is the tenant who hasn't paid during a protected time, and one is one who hasn't paid during a transitional time. The protected time is from March to August of 2020. The transition time period is from September to January of 2021. There's also a provision in the law for a high income earner, and then there's some new disclosure requirements that landlords are required to disclose to their tenants. There's penalties, which is new in this law, which is obviously very bad for landlords. And then the biggest grab in the law is the just cause evictions, what that applies to now. We'll also go over a little bit about lease violations and late fees, and then we'll touch briefly on the moratorium that the CDC put out that's nationwide. To start off with, the protected period is March to August of 2020. So if you have a renter who has not paid rent during that time period, you are prohibited from filing an eviction for uncollected rent during that time period. You are able to now notice the tenant that they have to pay the rent or quit. It's a different notice than what we're used to, which in the past we were a 3-day pay or quit. Now it's a 15-day pay or quit. And in addition to that language, it also has some language surrounding the tenant declaring that they're having a hardship because of COVID. The law makes it extremely easy for the tenant to basically say, yep, I didn't pay the rent because of COVID, and that's all that's required of them. It doesn't mean that the rent's not due to you. You still can attempt to collect the rent, but no longer can you do it in the traditional manner by filing an eviction for that. We'll talk about how to collect it after we go over the transition period. So the transition time period is from September of 2020 to January of 2021. Same thing applies here. You can't evict based on unpaid rent unless they haven't paid at least 25% of the rent due. So if your tenant pays at least 25% of the rent due, then you cannot evict them for the extra 75%. If they don't pay the 25% and they pay zero, then there is a provision in there to move forward with an eviction. The problem is they don't have to pay that 25% monthly. They have until the end of January to pay it. So they could literally not pay any rent, and then the last day in January pay the 25%, and then you wouldn't be able to evict them. So they still owe the rent, but you just can't go through the normal process. So what they've made provisions for now is for landlords to take tenants to small claims court. Well, in our area, the owed rent exceeds the normal limit of what you can take someone to small claims court for. They have made an exception. So if it's for uncollected rent, there is no limit, and there's no limit to how many times you can take a tenant to small claims court. It's difficult to collect on a judgment from small claims court. This definitely is a disadvantage for the landlord, but that's what the law says, so that's what is available to us. I want to talk about there's a provision in the law for high income earners, and it basically, I think the intent of it is, if you have a tenant who makes over $100,000 or 130% of the gross median income for the area, they are making that tenant actually document their hardship. The problem is it's not clear what they have to document it on. It's very vague, and it doesn't go any farther than that. But to do that, it requires a separate court proceeding that a judge presides over, which translation for the landlord is you need an attorney. It's very expensive to do. In conversations I've had with our attorney, they're saying this is not worth it, because even if we get the tenant in court to document this, all they have to do is document it in basically any way that they want, and that's it. So this is something that they are recommending we do not do, because there's no, the reward is not worth the risk. Because if you recall, this law also has real financial penalties for not following it. It's not just a slap in the hand. So we're not recommending that anybody push on that high income earner limit. The other big provision of this law, which is a big change, is they have now basically grabbed all residential properties and made them subject to the just cause eviction law that was just enacted in January, along with the rent control law. So in that law, which we disclosed to all of our tenants, most single family homes and condos were exempt from just cause eviction. That is no longer. This law now captures basically all residential properties are now subject to just cause eviction, which means you can't just give your tenant a 30 or 60-day notice and tell them that they have to move. You have to have a reason for it. It has to be documented, and in certain cases you will have to pay your tenant to move. They also strengthened those reasons. So one of the reasons in the past was you were going to make substantial improvements to the house, so you needed the tenant to move out. Well, that only applies now if there are serious health and safety issues, and that's what you're trying to fix, which is a much higher bar to meet. There is one provision in here that is a benefit to landlords. It's if you're going to sell the house and you can prove that it's going to be occupied by the person who buys it and it's not going to be bought by another investor, then you can proceed with giving a tenant notice to move. So a bright spot in this law is it doesn't impact our ability to charge late fees, and it doesn't prevent our ability to file evictions for other reasons. So if you have a tenant who's violating the terms of the lease, not related to COVID-19 non-payment of rent, then you can proceed with an eviction, which previously we were not even able to evict for those reasons. The law gave the courts until October to have lawyers be able to file those cases. So if you have a case that's not related to collection of rent, I think October 5th is when you're going to be able to file those evictions. So the CDC, which is the Centers for Disease Control, put out a nationwide eviction moratorium for people who are having trouble paying the rent because of COVID-19. The governor of California came out and said that this law doesn't apply to California because AB 3088 already meets it or exceeds the provisions in the CDC moratorium. There's nothing in writing. The governor said he was going to try to get some clarification. So right now we're not even really going to talk too much about it, but if we find out for sure whether it applies or not, we'll make sure we let you guys know. So that's the law, but the question is, what do you do now if you have a tenant who's not paying during those protected or those transitional periods? Well, if you're one of our clients, we're on top of it. We're going to be reaching out to you. We've also obviously connected with our attorneys on the best practice moving forward. We're going to be using them to assist us in making sure that we comply with all the provisions of the law. We are able to move forward with those 15-day notices, which we intend to do. If you're not one of our clients, I strongly suggest you talk to an attorney. You do not want to make a mistake when it comes to this new law, because there are serious financial penalties. If you have any questions, feel free to reach out to us, whether you're a client or not. We're happy to have a conversation and point you in the right direction if we can.